The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Ladies and gentlemen, my name is Judge John Arrowwood, and I am the presiding judge for this panel, which is panel 2 on February the 23rd. Sitting with me this afternoon is Judge Jeff Carpenter and Judge Fred Gore. We have one case on for argument, Cousins v. Cousins, 19-1152 from Mecklenburg County. And is the appellant ready to proceed?
Yes, we are, Your Honor.
Please go forward.
Okay. Good afternoon. May it please the court. My name is Rebecca Watts, and I am here on behalf of the defendant appellant, Terry Cousin. And we are going to be asking you to reverse the trial court's alimony and child support order because we believe the trial court made several errors. The more straightforward or simplest.
What is this? Is there still a custody case pending?
Yes, there is, Your Honor. Well, at the time we filed this, the custody order was not entered. I do not know if the custody order has yet been entered, but it had not yet been entered when we appealed this order.
So with respect to your arguments for attorney's fees, this case is interlocutory and not covered under 50-19.1, is it?
Your Honor, that is correct. In my statement of grounds for appellate review, I got into a substantial right analysis about attorney fees. I then did not actually end up making an argument about attorney's fees in my brief. I only argued about the child support and the alimony.
So are you waiving any complaint with respect to attorney's fees?
Yes, I did not make the attorney fee arguments in the brief, so we waiving that.
I noticed you went into a substantial argument about it.
I did.
And I just had a couple of questions, but since you were abandoning that, we'll move on.
And I realized that when I was looking over this, that I had not gone back and revised the appellate review section once I decided to take out the attorney fee argument. So I apologize for you guys having to wade through that, but it was just the child support and the alimony order. The most basic error we're arguing about is believe the trial court incorrectly calculated Mr. Cousins' income. And also there's a problem in the almost 15-month delay in entering the order, which caused the income numbers to be stale. But
now, Ms. Watt, I want to make sure I understand everything that's in the record. Were any of the documentary exhibits other than those in the Rule 9B5 supplement, were there any other of the exhibits put in the record or transmitted to the court? Particularly Exhibit 61, which was the 2018 pay stub.
If
I don't find it, is why I'm asking.
Okay.
I just don't want to overlook it in a voluminous record.
I thought that was in the documentary exhibits. I can check further on that.
I'm looking for the documentary exhibits, and I did not see it in that one, but maybe I've overlooked it.
Okay. And I can check back over that again and can add that as a supplement if that would be helpful to the panel. If it's not already in there. I thought all the pay stubs had been in there. And we're not disputing what the pay stub says. The pay stubs actually say. What we take issue with is a trial court using a prior year's income without sufficiently stating the reasons for not using the current year's income. I don't think there's any dispute over what he said his current year's income was or what everybody said his prior year's income was. There's the problem in that using a prior year's income without the sufficient explanation. But the bigger problem for child support we get into when we've got a conflict between what the guidelines themselves say about their applicability and what case law says about what income you're supposed to use to calculate child support. And I think part of the guidelines say you use the guidelines in effect as of time of trial. Case law says you use income as the date of the entry of the order. And when the guidelines were first promulgated in 1990, we were operating under an older version of Rule 58 that talked about a judge being able to render a decision from the bench and the clerk make a notation, and that was the entry of the order. So it was immediate after the trial, or a judge could render a decision later. When that was amended in 94 to the version we have now, that a judgment is entered when it's reduced to writing, signed by the judge and filed with the clerk, there's never going to be an immediate order. Order is always going to be after trial. Usually it's not going to be 15 months, or hopefully it's not going to be 15 months. And even when there is a delay, you might still have a problem of, well, this might be stale income information, but you're usually not going to run into a problem where you have a completely different set of guidelines in effect. And even if you have a completely different set of guidelines in effect, the number might not be very different unless you're dealing with a case like this, when under the guidelines in effect at the time of trial, it was an off-guideline case because their combined income was above the threshold to use the guidelines. But by the time the order was entered, their combined income was within the threshold to use the guidelines for their combined income. So I think the guidelines themselves have not kept up with the changes in Rule 58. It made sense back when you could have a rendition that was the judgment, but not now. So there, it was nearly 15 months. It was about 14 and a half months, late February 2018 to early May 2019, till the order was entered. This case law about using the actual income at the time of the order was made. In my brief, I cite to a fairly recent case, Kaiser v. Kaiser, which is from 2018. But if you backtrack that to the case Kaiser cites and the case that cites and the case that cites, you get well back into the early 80s or late 70s. So this case law about using income at the time the order is made well predates the guidelines, but also continues to be cited and used now. So that is still good law. Use the income as a date the order is made. So the guidelines then saying that they are only effective based on date of trial is just an inherent conflict. And as I talk a little bit about in my brief, in Carson, this court talked about what to do when you have a conflict between case law and guidelines. And when you have a conflict between case law and guidelines, case law has to prevail because the guidelines are not part of the statutes. The formation of them, the directive to create them is in the statutes, but they're created by the Conference of Chief District Court Judges.
But if they are created based upon the statute, then why do they not have the same effect as statute? If they're created pursuant to the statute, and the statute says you shall do X,
Right.
and they do X, then why is it not the same as statute?
And the statute tells them to do X, but it doesn't tell them specifically what that looks like. It doesn't direct them as to what the effective dates of the guidelines are. It directs that they be updated. The statute doesn't tell them update and make the effective date based on the trial. It does not tell them what the numbers are to be.
Does the statute say update every so often?
Yes, at least once every 4 years.
So the statute does say when they are to update, correct?
Yes. The statute does not say when you update in 2019, make those effective dates tied to trial. It does not say that. And so the actual crafters and creators of the guidelines are the Conference of Chief District Court Judges. And like I said, this court recognized in Carson that that is not a legislative body. And so it's not, the specifics of it are not statutory, and case law comes from this court, from the Supreme Court. Those have got to prevail over the actions of the Conference of Chief District Court Judges. And there have been several times that the guidelines have been updated or tweaked based upon rulings from this court when there's been a conflict. And Carson was one of those conflicts, and the text of the guidelines was updated to reflect that. So a couple of ways to remedy the conflict. One way is to say that the time the order is made for purposes of deciding what income to use really means the time the trial ends. That I think is a huge mess, because the trial court may actually not render its decision when the trial ends. Trial court may render its decision weeks or months later. And
when the decision is rendered, it's effective from what day?
When the decision is rendered?
When Judge Mann signed the decision, when do those new alimony orders and child support orders, when are they effective?
Well, the order is effective. This one was May 3rd, 2019.
And were the new orders of how much child support someone owed, was it calculated from that point, or was it calculated from the end of the hearing?
It was calculated beginning April 1st. So it did set child support back to April 1st, 2018.
So it set the child support orders were effective for your client's obligations to pay them back to the end of the hearing. Isn't that correct?
Yes. Well, slightly after, a little over a month after the end of the hearing, because the hearing ended at the end of February 2018, and the new obligation was effective April 2018. So I did not get into problems in the brief, problems that arise when you say in May of 2019, you order somebody to do something in April 2018. That is a problem. The judge did not attempt to make it a not pro-tunc ruling. I don't think it would have been appropriate for that anyway, because I don't think there was she didn't render the decision and then has some problem with it getting entered. I think she did not render the decision at the end of the hearing, but at a later time. And I don't know how late after the hearing she actually rendered her decision, and how much of this 15 months was waiting to know her decision or going back and forth over the order. But I think it is problematic. It's not part of this appeal, but it is problematic to say, today I'm telling you to do something last year. I don't think that fixes the issue of the conflict between, we're supposed to use income as of May 2019, because that's when the order was entered, but we use guidelines from 2015 because that's what happened at trial. So
it is not unusual in complicated domestic cases to have it take a long time to get orders entered. Isn't that correct?
That is correct, Your Honor. I would say in this case, it was not terribly complicated. He had W-2 employees. It was treated as an off-guideline case. It was not trying to figure out incomes from businesses or investments and assets. The child support part of it should have been fairly straightforward.
At the same time the child support order was entered, there was also an order entered on equitable distribution. Was there not about the same time?
The equitable distribution order was actually entered much earlier. The equitable distribution order was entered in July 2018.
And it was also the subject of an appeal, is that correct?
It was.
And that appeal opinion has come down, is that correct?
It has, Your Honor. It has. Yeah, so the court entered the ED order in July of 2018, the child support and alimony order in May 2019. I'm not sure when the custody order was entered, if it was entered. And so that was not, you know, a terrifically long time between the trial and the ED order, but between the trial, the time between the trial and the end of the applicability period of the guidelines it was tried under was 11 months. So this is not a situation where the trial was it was December 1st and the guidelines changed January 1st and the order was entered January 2nd. And it's like, wow, you know, we really tried to get this order entered, but everybody was out for the holidays and we're just now getting it done. This was 15 months. And if the court had entered this order anytime before December 31st of 2018, so if it entered anytime in the 10 months after trial, we wouldn't have this issue.
I'm more interested right now. We've beat this horse to death, perhaps. I'm sorry. I also have some interest in how the number, and this will be for Mr. Johnson as well, how the number of it appears that the income contained a large bonus number and I'm trying to determine how that is. It appears to have the bonus number from 2017 in it. Is that correct?
Yes, Your Honor, that is correct. The trial court found his 2018 income to be equivalent to his 2017 income, which included his 2017 bonus.
And if we should find that that's not supported by the evidence, do we reach any other issue in this?
I think you do still have to reach the issue about the conflict in guidelines, because even if Your Honors agree that the court should have used our income numbers instead of the prior's income numbers, there would still be a difference, granted not as large a difference, but there would still be a difference in calculating on guideline support under the 2015 guidelines and on guideline support under the 2019 guidelines. That may be in the matters of tens or hundreds of dollars instead of thousands of dollars.
Well, but we also send it back and say the judge didn't make enough findings with respect to how they came up to this and have them make the findings.
Right.
And if we send it back for that, does it require us to reach anything else?
If you send it back with a direction to the trial court, redo these findings based on the evidence that was in front of you in February 2018, or whether you send it back and say you may take more evidence, essentially a new trial or renewed trial, I think would make a difference. If you send it back and say you may take more evidence and the trial court essentially holds a new trial now, then would be using 2021 income under the current guidelines. If the trial court says, I'm just going to tweak my findings to reflect what the income should have been, you've still got, I think there's still a conflict that would be resolved.
You would agree with me, would you not, that the trial court would have used the 2017 income as of 2018 if they had made the proper findings about why they're using that as opposed to what they used.
Yes, absolutely. Certainly could have done that, and could have made findings that the evidence of the current income was not reliable, or was insufficient, or was incomplete, or that he was depressing his income. Yes, the trial court could have offered an explanation for why it was using prior year's income.
Ms. Watts, traditionally, what would happen in that situation with the court is that the trial court would take the last 2 years and average them. Is that not correct?
And I didn't hear, I'm sorry, I didn't hear the very beginning of your question. Were you asking if it would have been proper for the trial court to take the last 2 years and average them?
Well, as I understand it, there's 2 options available to the trial court. First, the trial court could have taken the 2017 earnings, made the proper findings of fact as it relates to 2018 and made a calculation. Certainly that's an option.
That's an option.
It's sort of built into the guidelines and the statutory interpretation and I guess our case law as well, that if you don't have the reliability, generally based on bonus income that's somewhat unpredictable, the court presumably will take the last 2 years that are known and average those to come up with what the income would be. Is that not correct?
That is, and in this case, 2016 and 2017 were different because the bonus amount was different in each of those years. So even if the trial court had averaged 2016 and 2017, I think it would have gotten a lower number than just using 2017 because there were only those 2 years of bonus history. And if the court is going to use the prior 2 years and average them, the court still needs to make a finding as to why they're doing that. Also build into the guidelines to deal with bonuses. And I understand that the court treated this as an off guideline case because the income it calculated was above it. But the guidelines have 2 different ways of dealing with bonuses. If you're dealing with an on guideline case, you can either average the bonus out and make it part of the monthly income, or you can say this bonus it's not certain, it's not reliable, it varies. So we're going to calculate child support just based on actual monthly income. And then when the payor receives a bonus, whatever the payor receives, the payor pays a percentage of that as additional child support. So, for example, if the monthly child support obligation is equivalent to, say, 10% of the payor's gross monthly income, then the payor gets a bonus and pays 10% of the gross of that. That has always seemed to me a much simpler, a fairer way to deal with bonuses that are not guaranteed or not predictable in their amount, is to say, we're going to calculate child support based on what you actually have in your bank account, what you actually put in your pocket from work every month. And then there's going to be this percentage of the bonus, just like you would if you guys were still living together. And I think that actually fits the purpose of the guidelines of providing the child with the support they received if the parties were together. So
Ms. Watts, on another issue that in the interest of time, I want to touch on before you run up. How, looking at the Britt case and looking at your brief, how does the delay affect this court's ruling? Is that separate and apart from your argument of the findings in the calculation?
My argument about the delay is that the delay caused the income numbers to be stale. And so that the order was not based on income as of the date of the order because the last evidence was 15 months old. And there's no way to know what his income actually would have been. And the other part of the delay is just the prejudice that arises from the delay with the changeover in guidelines, causes the child support numbers to vary greatly. But mainly the delay, and I think the case law in other areas in alimony and ED have talked about, especially in alimony, making the income numbers just no longer no longer current or no longer ripe. So that is another way for you guys to send it back on the income. Either the judge didn't calculate his income correctly, or the income numbers were stale as of the date the order was entered because it was too long. So let's send back and get fresh numbers.
There
aside
has
from-
been a case where we have said you've got to render a decision within a certain number of months or it's stale, is there?
No, it is every case has been on a case-by-case basis. And in some of the case law, this court has gone into kind of some of what the factors you look at to see whether it's been too long. But no, there's no bright line. And I did not find any specifically in child support that say, in this case, this was too long. So I talked about equitable distribution cases and alimony cases, but no, this court, to my knowledge, has never set a bright line for what's too long. It just is it too long in this case, based on the circumstances in this case? Well, if your honors have no further questions, I'm under the 5 minutes here, and I'm happy to ask more questions now, or otherwise I'll just reserve my last 4.5 minutes for rebuttal after Mr. Johnson gives his presentation.
Mr. Johnson, please proceed.
Good afternoon, may it please the court. Richard Johnson for the plaintiff appellee, Carmen Cousin. If I may, I'll pick up on that last point about the delay of the orders. Counsels, likewise, I have not found any cases on point regarding child support and delay of orders. Most in a domestic context, there's various cases around equitable distribution when there's a delay and it affects the value of a property as there's a delay. And the case laws indicate that it's got to be taken on a case-by-case basis. And the biggest factor is, was there any prejudice? Now, there is a case, John versus John, which was an alimony and child support. This court affirmed a trial court when it was a 20-month delay in entering the order. And in that case, the trial actually carried over a period of 2 years, I believe. So it was stretched out over a very long time, but the court there found no prejudice and affirmed the trial court. So it's a case-by-case basis and whether or not there's been prejudice, but there's, besides John, I did not anything on point regarding alimony. And nothing regarding child support.
In your Rule 9 supplement that you sent up to us, you included certain exhibits, including one was an employment agreement, which that you submitted, and this employment agreement appears to have terminated on May the 31st, 2017. At the time of this hearing, was there an employment agreement at all?
I did not see that in the transcript. He was still employed with the Pittsburgh Steelers. So I was not aware whether or not he signed a new one or they just, he carried on under the same salary. Now, based on his affidavit that he filed in right before trial, his base salary was almost the same as this $155,000, maybe a little higher, $158,000. So it would appear, it's not clear from the record from what I saw whether or not he signed a new agreement or is just following this agreement informally. But
you would agree with me, would you not, that what the trial court did with respect to income is that Judge Mann took the income that was from the 2017 W-2 for the current income, did she not?
yes, she did. And
she didn't make any findings with respect to why she was doing that, as opposed to finding what the new income would be, did she?
Did not, no, the order, I think it's findings 19 in the record on page 161. The finding just states what his income is, which is total gross monthly income of $23,021. Part of that was some rental income from rental property he had, but that basically mirrors what he claimed, what he earned in 2017. But there's no findings beyond that indicating how she got to that number. Now, the issue obviously is the bonus. That's the number that moves, is the moving that changes the number with the gross income. In 2016, his bonus was $58,000. In 2017, it was 103,000. And both during direct and cross, Mr. Cousins was asked about that. Well, more so on cross, and the plaintiff's counsel was asked him, you only listed 1,500 on your affidavit. How'd you get that number? But it didn't really go too far. And he said, I believe, he said, I didn't get it, but based on the employment agreement, he gets the bonus later in the year. So in February, when they had the trial, he wouldn't have received the bonus yet. But
Well,
even on direct,
based on his previous employment agreement, the bonus was discretionary, was it not?
I believe, yes, at the discretion of the club. But based on, it also says that at the end of each year, now it doesn't say football, well, it's either the football year or the calendar year, but it says at the end of the year. So no matter whether he was entitled to it or not, he wouldn't have had it in February of 2018 for 2018. But and on direct, he really didn't explain how he got $1,544 for a monthly bonus, which I think adds up to $18,000 for the year. So there's no explanation of why he put $1,500 a month on his affidavit for a bonus.
Well, who has the burden of proving what his income was for this?
Well, the person receiving support has the burden to prove what the payer's income is. It is their burden. One other thing I want to point out is that the judges using, in these cases that are referenced in the appellant's brief are cases where the court, there's either an issue about possibly bad faith in imputing income or unreliability of the income. And you mentioned the 2018 pay stub. It's not in the supplement, but I believe it was part of the defendant's exhibits. And I think there might have only been one, because they're in trial on beginning February 20th. So there wouldn't have been much of, if any, of his 2018 income. The Judge Mann used the 2017 income information was barely a month old, a little over a month old. So it's not, this is distinguishable from these other cases where the court has a lot of information about the current year's income and then goes back in time because it's either unreliable or they think that the income is too low.
Mr. Johnson, wouldn't that still require findings to support that stance by the trial court? Even though I understand your argument that we're fresh into the 28th, but wouldn't there still be a requirement for findings to explain that, to establish why the trial court did that?
Arguably, and again, because of the bonus, his base pay appeared to be the same for the most part. So, and that's what he had on his affidavit, his base pay. But how the judge arrived at the total income and the moving number is the bonus is not clear from the finding that is there right now. So his bonus did go up. I didn't see anything in the record to indicate that his bonus in 2018 could have possibly been even higher than 17, but I did not see anything in the record to indicate how the how the court came to that.
But the court did find in paragraph 117 that the bonus was 48,000 one year and 103,000 the next year. Is that correct? I believe.
Yes.
And the court used the higher number in determining his income. Is that correct?
Yes, it did. The most recent and the higher number.
And what evidence is there in the record that it would be the same in 2018?
I did not see anything in the record that it would be the same, that as they sat there in court, there was nothing offered as to how it could change or be the same or less or anything to that effect.
And as you, I believe, answered to Judge Gore, Judge Mann did not explain how she came up, made no findings as to how she came up with that number as 17 as being the number at the end of 18. Is that correct?
Correct. Well, there's findings 18. Findings 18, the last sentence is, defendant received a gross monthly income from the Steelers in the amount of $22,688. And then in 19, it goes on, second sentence, defendant has a gross monthly income from the Steelers in the amount of $22,688. So the court is using the 2017, but does not explain what part of that is base pay versus what part is bonus.
But the 22,688 we know included 103,000 in bonus. Isn't that correct?
Correct, it did. Yes. And if I may, also to touch on the initial issue that came up regarding the the conflict between the guidelines and then the case law that says entry of order or when the order is made. As well as the court might be familiar with district court practice in domestic setting, that typically an order is very rarely entered, if ever, right there when you're in court. So the judge will often render a decision and then direct one of the party's attorneys to draft the order and then send them off on their way. I've found my experience, some judges are more stringent with timelines. They draft the order in 10 days, get it to the other party in 10, get it to me by such and such date. But I think that's a minority. This idea that there will never, if ever, will be a time when the child support matter is heard and then the order is entered the same day. It just doesn't happen in reality.
Mr. Johnson, on that issue though, Mr. Johnson, would you say that it is also in the minority that 15 months on a case that does not have business and other substantial investment calculations would be in the minority as well?
Yes, I was thinking about this as I was preparing my response. I mean, I think the general, most of the time it's maybe 0 to 3 months by the time it gets entered, and sometimes 3 to 6. But once you get beyond 6, it doesn't happen that often, but it does happen, unfortunately. And sometimes goes beyond a year, which, but most of the time there's a month period from 0 to 6 months where between the hearing and when the order gets entered, between the attorneys going back and forth. Sometimes somebody asks for an audio. So those kind of delays. Now I did.
Is there a way, if counsel believes that an order is taking too long to get entered or the judge is not doing, is there a way to force that to happen? Something
Uh,
like a petition for
yes.
mandamus, perhaps?
Yes, Your Honor. Yes. Um,
Was there anything like
and-
that ever done in this case?
I don't think so, because and I did notice on the last transcript, the last day of the hearing, that it appears that the attorneys were returning back in front of the judge in a week or two. We don't have that transcript, so I believe she probably rendered her decision on that day. So we don't know what happened as far as the back and forth with the attorneys after that point. So in my experience, the writ of mandamus is when there's no ruling or no decision from the trial court. But based on what I saw in the last day of the transcript, I think the ruling was given within a week or weeks of the last hearing. But none of us were the trial attorneys. We don't know what happened in the back and forth that it took 10 months to get finally entered. You know, if it's just between the attorneys, then there's not really an issue of writ of mandamus. Now, I know this problem in some counties, the court will set an order review date, and that's even been bannered about some, because where you have to come back in before the judge in, say, a month or two, just to see an update on the order, to enter the order. Cabarrus County is one that does that. They have a specific day for entry of order. And this kind of keeps track of things so that they don't meander forever. But there's not one system set up. Each county's different, and it's different with judges, but except, you know, Cabarrus is the only one I found that does that entry of order conferences.
There's not an order like that in Mecklenburg, is there?
No, it's been discussed, I think, in some ways with the bar, but nothing's ever been formalized to have a specific day to enter orders. But it's every attorney's goal to have these entered, put them down in writing as quickly as possible, because as more time goes on, memories get stale. You have to order a transcript. So, you know, there are attorneys who will put these things together right away and then send them over to the side, which is the best practice, obviously.
Is there anything in the record that indicates when Judge Mann directed the lawyers or directed your predecessor to draft this order?
Not in, I believe there may be, I'm assuming that was put on the record when they came back in a few weeks after the last hearing, some type of transcript. I assume there's a transcript of what happened then when the judge gave a ruling, but.
But we don't have that, do we?
No. And I guess part of in these cases that talk about entry of order, they use different terminology. That the quote is, when child support is determined or alimony is determined, it should be based on the the party's income at the entry of order. Some say entry of orders. Some say at the time of order. Some say time of the award. And I believe when that language, even though it's saying quote order, I believe it means at the time of trial or hearing, not the strict Rule 58 sense of these formal entry of order, because of this issue that you know, there can never be at the same time the order entered at the time of the hearing. And some of these cases that talk about time of order or time of award are newer cases since the change to Rule 58, the update of Rule 58. So I think it's a loose term of art that the court's using, saying that instead of saying time of entry of order is referring to time of trial, that when the hearing occurs, that's when their party's income should be used. So I think we're getting into semantics about this, the cases that talk about incomes at the time of order. I don't believe it's order in the sense of the physical order that's entered.
So, Mr. Johnson, question. In regards to the entry of the order in this case, district court practice, certainly the judge maintained jurisdiction over the case until the order was entered. We agree on that?
Yes. Mhm.
Okay. Certainly within the judge's discretion to request of the parties to update the income immediately prior to the entry of the order, correct?
Yes.
So let me have you touch on the rule, not the rule, the issue of the 2015 guidelines versus the 2019 guidelines applicability in light of the timing of this case. You've talked about it some, but give me your position on that.
Well, the guidelines, the opening paragraph talk about, well, the 2015 guidelines say on the first page, these revised guidelines are effective January 1st, 2015 and apply to child support actions heard on or after that date. And then the same for 2019, except it says revised guidelines are effective for January 1st, 2019, apply to child support actions heard on or after that date. And it's my position that heard is trial. And that's that, you know, this trial was in 2018 before the change 2019, and the judge used the 2015, which I thought we argue that's the correct application of the law. And then this argument that this conflicts with the case law because of the entry of order language. I believe that entry of order language is not talking about entry of order. It's talking about at the time of trial. That there is no conflict, that this is merely when the court in the case law is talking about come at the time of entry of order, it's talking about entry at the time of trial. So we believe that the court was correct in using the 2015 guidelines.
So let me touch on that a little more. The reason that it makes a big difference in this case, the 2015 guidelines, this is an off guideline case. Basically, the guidelines aren't applied because the combined income exceeded the max, exceeded 25,000 under the 15 guidelines. The 2019 guidelines, that max was bumped up to 30,000. It would be within that, and there's a pretty substantial difference in the two numbers. The one that was derived under 15, where the guidelines weren't applied, versus the number that would be rendered by application of the guidelines under 19, which also affects the alimony order potentially in regards to the ability of a spouse to pay based on the adjustment, if any, in the child support amount. So that's why it's an important issue for me to get my mind around on that. That's why I kind of want you to drill down on that. We dove into it pretty deep already. If you want to add anything.
Yeah. In this case specifically, his income, Mr. Cousins' income under the 19 guidelines would fall within the guidelines. So the number would be, and I think it's a footnote in the appellate's brief. So the number would be much less. Now, you know, what that potentially does, though, as far as in the whole numbers in alimony versus child support, is that maybe frees up more money for alimony if his child support's less, based on, I think it's FINK, but where if there's a child support order that the court factors in the child support obligation as the payer's expenses. And then, so arguably, he's going to pay the same amount. It's just going to, if the child support's less, it maybe frees up more room for alimony. And the alimony is $700 a month. So
depends on what the dependent spouse's need is, correct?
Correct. Right. There's always the ceiling of her needs. And I don't know. I think the 700 was less than what the court found that she needed. I think it was way above that. through the order, but, yeah, her needs were way above the 700. So, but based on the child support, the judge found that he could pay was the 700.
Okay, thank you.
And that's all I have. And again, these, I think we're blurring the line between this entry of order versus date of trial, because not every court used the entry of order. That's all I have. Thank you.
Thank you.
Such part of the, I'm sorry, yes.
Was there another appearance before the court that there's a transcript we don't have?
I honestly do not know if they had that follow-up. When I got the case from the trial attorney, this is what I was told the trial dates were, and that's the dates we got. I was not told anything about
Did
that.
the transcript, though, specifically reference another hearing?
It does. That does not mean that actually happened.
Do you have an obligation in putting this together to determine whether or not it happened, and if it did, to provide it to us?
I'm not really sure how to answer that.
I would suggest the answer is yes. Obviously, and I don't know if it happened or not. So I'm not saying you are trying to hide something from us. I'm just saying it's a question I have.
No, and I do not know that it happened. And it would not have been until we actually got the transcript from these trial dates that we even saw that there was potentially another day. But no, I did not go back and check with the trial attorney and say, did you have this follow-up? My understanding from talking to the trial attorney was the judge had rendered her decision much later. My understanding was not that the decision had been rendered a week later. And that kind of was part of the explanation for why the ED order was several months later, and then many months after that, the child support order. And based on my conversation with the trial attorney, my understanding was the judge was rendering piecemeal decisions and did not actually have them all back. But I cannot say for sure whether that meeting, whether that actually happened, or if it didn't happen, or if the judge emailed them instead or said it's going to be later. And certainly it's not in the record, but just my understanding is that the decisions were rendered one at a time and later.
Ms. Watts or Mr. Johnson, do either of you know whether this order was actually prepared by one or both of the trial attorneys, or whether it was prepared by the court?
I believe it was prepared by the trial attorneys.
Okay, thank you.
Judges ordinarily do not prepare the orders unless it is a double pro se case or a child support enforcement case. It's usually going to be given. And we do technically have a local rule in Mecklenburg County that says the orders are supposed to be entered within 21 days following the hearing. Obviously that doesn't often happen. And, you're not going to get really an immediate child support order unless you're in child support enforcement. So
It never happens in Mecklenburg County, does it?
it never happens in Mecklenburg County. I do want to just briefly talk about Mr. Johnson's position that entry of order really means date of trial. That runs afoul of so many support and ED cases where this court has said that the income or the property values are no good as of the date of the entry of the order because it's been so far from trial. If the rule were entry of order equals date of trial, we don't care what Rule 58 says about when the order is entered. If we're really going to say entry of order means the last day of the trial, then all of these cases where this court has said it's not based on income as a date of entry of order, it's not based on values as entry of order because it's based on income and values as a date of trial, it would have never happened. But the answer in those cases would have been, those numbers are fine because entry of order really means date of trial. So entry of order cannot mean date of trial. And Rule 58, the revision makes it abundantly clear that when entry of order is.
I have one more question,
Yes.
and it's gonna run you past your time, but I'll give you some more time to answer it.
Okay.
Isn't there normally some sort of record from the trial court directing somebody to draft an order to say X, Y, and Z? I mean, I never practiced domestic law, but in every case I ever had, when I won or when I lost, there was either the judge said from the bench or there was an email or something. And isn't that supposed to be part of the record too?
So
In this type of case where it took this many months to get it done.
So kind of the first part of that question isn't there, some sort of directive tell them what to do? That's going to vary very much on the case and the judge. You could have a judge just say, here is my end game. Here is my end result. You guys go draft the order and fill that in. And then there's always lots of questions and problems. Well, the judge didn't actually tell us that was a finding. We're having to put findings that match what the judge said. The judge just could say, I find, a guideline child support to be $1,200 a month. And then you're left to draft an order to figure out how the judge got there. Some judges may say, here's my typewritten bullet points of the relevant issues and findings that I use to reach there.
But
And
we have nothing.
we have nothing. Yeah, you're right. We don't know whether this was an email, whether this was a phone call, whether this is back in court, whether Judge Mann said, here's, my details, or whether Judge Mann just said, here, his income is X, her income is Y. That's above the guidelines.
Whose
Yeah.
burden is that to put in the record?
I'm sorry.
Whose burden is that to create that for the record or put whatever happened into the record so we didn't have it?
If it exists, then it would certainly be my burden to put that in there. If it's not in the trial court, if it's not in the court file,
Well, you should have gotten the file. I'm not saying that you did. I'm not saying that you got all the info from the person who had it before, but you should have gotten something from them that explained how we got here in 15 months.
right? And I do actually have 3 boxes. I have the entire trial court attorney's file in my garage right now. That's 3 boxes that I went through for the 2 different appeals, and looking through the court file that's, lives in Mecklenburg County. And I did not see anything in there to show how the judge rendered her decision.
Ms. Watts, would that be indicative of it taking 15 months to get an order? Is that potentially a part of why we are at 15 months to get an order?
You mean because there wasn't anything
There wasn't a
given?
charge, there wasn't a quote unquote charge conference to come up with who was doing what.
Yeah, that's possible. We really don't know, without anything in the court file, the record, exactly how it took that long.
Well, Ms. Watts, before we let you go, you and Mr. Johnson, the reason I asked the question about who was tasked with drafting the order is I used to do some domestic work, and it would seem to me that if the wife in this case, if the wife's lawyer was tasked with drafting the order and Judge Mann actually announced what the order was in court, and then it was 15 months before the lawyer got there, that's an issue that comes into consideration when you're determining prejudice, if any exists. That's why I asked that question earlier. And it sounds to me like you and Mr. Johnson are both picking this up after somebody else did the courtroom stuff and maybe weren't providing a ton of information outside of what's in the file for the record.
Right.
And Mr. Johnson, you can answer that as well if you'd like. I mean, we're way into extra time, and that was a question to both of you, so you can answer it if you'd like.
Well, yes, 80% of my practice is in Mecklenburg County. Judge Mann has been there since I think 05, 08. It's been, I would be willing to bet that she directed one of the attorneys to draft the order, because that's kind of her procedure. But what happened after that, we don't know. But that is, in my experience, that is the experience, even with other judges in Mecklenburg. One judge will direct the attorney who, quote, won the motion or hearing to draft the order. And then, as I said before, some judges more stringent on time, but that's just a minority. I will say, though, that this issue, if I may, with the trial, if Judge Carpenter, you brought up about could the judge hold a little hearing to see before the order got entered to see if there would be updates on the income. But again, there's also, how do you measure the time? When do you do that? Do you do that after 3 months, 6 months, 8 months, a year? And then it also presents procedural questions. How do you, you have to do that every single time? There are those kind of issues that come up with, if there's a delay, when do you update the income? Where do you draw the line of how many months? And maybe, hopefully not year.
Well, counsel, it certainly has been an interesting argument, and you have each done well for your clients, and we will take it under advisement. And thank you for your efforts.
Thank you. Thanks for
Thank
your
you.
time today too, Your Honors.
Thank you. Thanks for your time.
All right, you can close court, Mr. Soar.
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.